So John, when someone comes to us and says, hey, look, I got an official filed GOMOR, or I got an Article 15 in my official file, or some other adverse information in their official file, is there anything that we can do to help?
There is. Under AR 600-37, which is the regulation which governs unfavorable information, under Chapter 7 of that regulation, lays out the process of how to appeal to the Army's Department of the Army Suitability Evaluation Board.
That's a mouthful.
It's a strange name for this particular type of process, and the title itself doesn't really help explain what this board does. This board is a faceless board that you don't have a right to appear in front of, but you can submit a packet to appeal to have unfavorable information on your record either transferred to the restricted file or removed altogether.
All right, so you can do both. Remove the record that's unfavorable and then transfer it to the restricted file.
That's correct.
And what does a soldier do if they want to remove or transfer adverse information in their file?
Various forms of proof go with either transferring the piece of unfavorable information or removing it altogether. In order to remove it altogether, you have to have a packet that proves with clear and convincing evidence that the unfavorable information was arrived at as a result of something that was unjust or untrue.
So let me understand. To put it into the official file, it only has to be by the preponderance of evidence, which is like 51%. But to remove it, the fact finder, the DASEB, has to have a firm conviction as to the facts asserted that they are untrue or unjust.
That's correct. And what you're essentially doing is going back and appealing and challenging the original underlying investigation, whether that's a CID investigation or a 15-6 investigation, and you have a higher burden of proof then in that sense. When the DASEB accepts a record and puts unfavorable information into your record, it is already assumed that the underlying investigation meets all legal qualifications and is acceptable.
My understanding is if I'm a convening authority and I put something into your official file, I can then, upon request by the individual whom I filed it on, they can ask me and I can then write a letter as the convening authority to that board to have it either removed or transferred to the restricted fish. Is that right?
That's correct. And one of the first steps, or one of the steps in this process, should be allowing your attorney to reach out to that convening authority who placed the unfavorable information into your record, because having their support is key and essential in trying to either remove or transfer the unfavorable information.
Well, I'll tell you personally, I just submitted a request to the DASEB to remove the DUI filing. And the first letter was from a now Lieutenant General who said, hey, this should not be there. It served its purpose. This guy is a great leader. We need to take care of this soldier. And that's about the strongest evidence we could get.
Right. When you have evidence of the actual convening authority who wrote the original information, unfavorable information, or governed its acceptance into your AMHRR, your Army Military Human Resources Record, otherwise known as the OMPF, then that is very strong and carries a lot of weight in either transferring it or removing the unfavorable information.
Well, what about other information? What else would you put in that packet?
Well, you can have the support of your current chain of command as well. I also had a case in which it was also a DUI case. We had the support of the original convening authority that wrote the unfavorable information. The chain of command at the time the unfavorable information was entered into the AMHRR, and then we also had the support of the current chain of command of the soldier. That was a very strong packet, and ultimately the unfavorable information was transferred to the restricted file, and that soldier was promoted.
Oh, that's an outstanding result. So what happens though if the DASEB says, no, sorry, good to go, it's going to stay here? What can a soldier do?
You are in luck. There is still one further higher level appellate authority, and that's the Army Board for the Correction of Military Records. And the ABCMR has a much broader authority and has the ability to look at a more wide and holistic viewpoint of the entirety of the situation to determine whether or not the unfavorable information should be removed or corrected in your file.
Right. And in fact, the Army Board of Correction and Military Records decisions can be appealed to a DOD level board, but it's only a paper review, and it's only a review of their findings. So, I mean, I guess the soldier gets 3 bites at the apple, right? Well, they actually get 4. They can ask it to be filed locally or not filed. They can then go to the DASEB to have it removed or transferred. They can then go to the Army Board of Correction and Military Records to have it removed. And then they can go to the DOD board to have it removed. And that could be a lengthy and costly process.
It can be, and your client has to be in it for the long haul. And part of the process is helping your client understand that it is worth the fight. Because if you think about it, if you're in the military and you want to make the military a career, then it should be worth every bit of effort on your part and your attorney's part to fight the long fight for you, because this has an aggregate effect on retirement and all the benefits that you're working so hard for every day at the end of your career.
If you got adverse information in your personnel file and you need to have it removed, give us a call. I'm Will Helixon, the Law Office of Will M. Helixon. You defend the nation. We defend you.